Hello, everybody. Welcome to the show. My name is Jacob Davidson, and this is and I'm a legal layman. And this is a show where I try to learn the law and educate while I'm learning. And welcome to it. I don't know why I've been apprehensive about calling this the legal layman show, but I think I'm going to start doing that from here on out. So, fascinating news for today. For the next 2 hours, hopefully, I'll finish before that so I can do some research on it myself. In about 2 hours, I should be joined by Legal Mindset from Andrew Esquire from the Legal Mindset to talk about Disney. Hopefully, he'll have a lot of informative information for me that I can take in. Should also probably repost the links to the other chats as well, so that way they can, be aware of this. Okay. Okay, cool. Is the is that stream still going on? Oh. Yeah, I'm not gonna. Well, that sucks. Conflicting streams. I was gonna invite the Racket crew to the stream. However, it seems I have been beat by Az, Sargon, and Rakeda today. Fascinating. Well, I will grant Az my views. So I'll just have that playing in the background. So, it'll just be my chat. Me, myself, and I. How about that? Alright, I'm just gonna make sure everything's started up, ready to go, and we're all set before I get started on the topics. And the topic tonight will be continuing and finishing up that, hopefully finishing up that qualified immunity piece. Also, if I look better today than I did before, I took a shower before I streamed, and I feel much better. Gonna pause that. You out. Just get that squared away. And before I get started, I want to show off something that surprised the hell out of me. Also, if you're watching this on the Rumble end, please go ahead and go watch this on the YouTube end, or at least go and click like on the YouTube end. And if you're watching on the YouTube end, go ahead and please go and hit like on the Rumble end. Cross subscribe would be fantastic. Keep touching my hair. I need to stop doing that. Wait a minute. Okay. Okay. Cool. All right. That's better. So that I will show this off. So I was just curious browsing through my videos because I was setting up my stream for today. And I went to my homepage and I looked and I have, all right, so 15 views already. Thank you everybody who's already come to watch. 208, which is not bad. It's actually much better to get views on Rumble than on YouTube. Easier too. Uh, this has 1,740 views. When did that happen? I was just reading the Declaration of Independence, the Constitution, and the original Bill of Rights. How? Man, I need to get a lot. I need to get some views on these old videos too. Is it because they're not tagged? Hold on, I'll just go to this side and check that out. I put tags on them. Damn it. And that Ghazni interview, though, that was something I was so damn excited for. It made me very happy. I will move the StreamYard window. And I'll let him know. Uh, alright, letting Mindset know the link. I don't know. I keep looking at myself and it's like, damn, fugly. Oh yeah, I should open up this window right here. Right here. OBS. Here. Ooh. Oof, wait. Oh, okay. Yeah. Alright, so let's get on to it. The documents. Alright, I'm gonna pull up my notepad from yesterday. The derogation standard. Path to qualified immunity. And I will note take on the derogation canon. Alright, so I'll put this right here, like on the screen. A, B. The critical commentary aside, the derogation canon in the 19th century case law. Critical commentary aside, the derogation canon was influential at times beginning in the late 18th century and leading up to Reconstruction. The United States Supreme Court first adverted to the canon in 17... Alright. First. And adverted... averted. Fuck me. Hello? Hello? Testing, testing. See if I'm still living. I salvaged it. Yes. All right. All right. Let's fucking go. That was frustrating as shit, though. All right, we're back at it. Derogation canon. A, B. There we go. All right, so I was looking up. The United States Supreme Court first adverted to the canon, referred to in speaking or in writing. So it started in 1797. Brown v. Berry. First instance in Supreme Court. A case in which the defendant argued that a claim on a debt that authorized by a Virginia statute passed in 1748 was not viable because the Virginia legislature had subsequently repealed the 1748 Act 134. The Supreme Court's resolution of this issue was complex, but turned in part on its holding that a 1789 Virginia law should be construed strictly in as much as it was in derogation of common law. Of the common law. By giving the statute a limited construction, the court held that the 1748 statute was still in effect and therefore authorized the plaintiff's claim. Wait, what? Which the defendant argued that a claim on a debt authorized by Virginia statute passed in 1748 was not viable because this is a complicated question, actually. Because a debt should be binding. Even if repealed, I think it kind of falls under what's it? Bill of Attainder sort of thing. The statute was still in effect and therefore authorized the plaintiff's claim. Thus, from the outset, the court used the canon to amplify common law claims, not common law defenses. A review of such Supreme Court decision addressing 137 to unearth and synthesize every relevant decision. Research Westlaw's database of Supreme Court opinions for different formulations of the derogation canon, including 1. Derogate as common law as derogate, legislate. 3. Parisum as common law, legislate, objecting to overturning, to a turn towards constitution and statutes, as if they had, alright, yeah, he did search. Occasionally addressing the canon that's cited after Brown shows that the court occasionally relied upon the canon in 3 categories of cases. Alright, cases 1. Category of derogation cases. 1. Those involving a novel procedural devices. 2. Novel procedural devices, those including statutes and arguably interfered with common law and property rights. Statutes that arguably interfered with common law property rights. Those in which, as in Brown, plaintiffs sought to bring a common law claim that the defendant argued had been displaced by a statute. A common law claim which had been displaced by statute. But none of the case law leading up to the surrounding Reconstruction would have given legislatures any indication that the courts would sub silentio incorporate common law defenses into a newly created cause of action like in Section 1983. And once again, in silent or without speaking, or without saying so. In the early 19th century, most cases applying to the canon fell into the first category. Most claims cases applying derogation canon went to novel procedural devices. For example, lawyers argued without success that statutes authorized so-called summary proceedings should be strictly construed because they were in tension with common law procedures that provided for a more fulsome hearing. This is 139. Okay, so 138 was, during this period, courts defended common law in the criminal context as well as objecting to turn towards constitutions and statutes as if they abolished every rule of action derived from our predecessors or even ourselves. So 139. Displaying argument by counsel that canon applied to procedure of some summary proceeding by motion. Containing arguments by counsel that canon applied to Virginia law providing summary remedy. And so Peyton v. Brooke, Virginia, or Stewart v. Laird, and Wilson v. Mason, featuring argument by counsel that statute regarding summary proceeding should be strictly construed. The canon was implicitly implicated in cases concerning the process by which judgment was executed, or the ability to bring joint actions as procedural rules evolved. The court confronted arguments that, and this is applying canon in context to executive execution of judgment, Mitchell v. St. Maxence Lessee, Fullerton v. Bank. The court confronted arguments that such rules, whether they be of evidence, 142, discovery, or jurisdiction, should be strictly construed when in derogation of common law practices. In some cases, these arguments held sway, and in others they were rejected. But none of the cases concerned common law defenses. Rather, the upshot of these cases was that the litigant could claim some legitimate reliance interest in expectation that common law procedures would be followed. This could carry with it some implicit expectation that the legislator will give clear and adequate notice when they mean to displace the common law. Arguing that if derogation canon has any continuing force, it is on its alternative justification, the principle of notice. Given how sharply the Reconstruction Act meant to displace existing relationships between state actors and federal power, however, and how broadly legislatures understood Section 1983 to apply, state officers had adequate notice that the Civil Rights Act of 1871 required adherence to constitutional norms. Hold on, I gotta count my calories real quick. All right. I can smell the mint off of it. Notwithstanding the occasional case in the derogation canon held sway, a derogation canon held sway, as statutory law proliferated over the course of the 19th century, the Supreme Court gave even greater consideration to indications that legislatures intended procedural innovations in Metropolitan Railroad Company versus Moore. For example, the court considered whether newly enacted statutes reorganizing the courts of the District of Columbia should be read to abrogate the prior practices in D.C. prohibiting certain appeals from denials of motion to set aside a verdict. The lower court held that no appeal could be brought because the practice in D.C. prior to the new act would have been to dismiss for lack of jurisdiction and an appeal of denial of a motion based on insufficient evidence. The Supreme Court acknowledged that this has been the practice in D.C., Maryland prior to the reorganization of the D.C. courts. But held that the canon disproving interpretation and derogation of common law practices was inappropriate because, one, Congress had meant to introduce into D.C. a new organization of its judicial system, modeled on New York's judiciary, and therefore Congress meant to adopt the laws of New York with respect to the question. Oh, wait. I forgot the note take. Fuck. Reorganizing D.C. courts. Read to repeal prior practices in DC. The old practices beheld the canons proving interpretation and derogation of common law principles was inappropriate. Was inappropriate. One, Congress had meant to introduce into DC a New York styled law or court. Two, Congress meant to adopt the laws of New York. Well, we meet again. And we do meet again, NC Native. Dude, the stream was fucked earlier. Which would permit the appeal by 1887. Then the Supreme Court accepted the legislature could innovate the contravention of common law exceptions about procedures. I'm gonna have to probably try to burn through this pretty quickly because I have like an hour left with it before I gotta be ready for legal mindset. So my careful note taking is probably gonna have to come to an end. And I'll come back and recap it probably another time. No, mindset's gonna join me, actually. Yeah. So is mine right about what? Of course you don't. His opinion and expertise in the Disney situation will be very helpful, though. All right. The Supreme Court accepted that legislature could. All right. The second category of case in which the derogation canon played a role implicated reliance interests more directly. Those involved common law property rights and their interaction with statutory innovations. One of the first cases to rely on the canon in this way was in 1812 decision in Fairfax Devisee v. Hunter's Lacey, in which the court held that the Virginia statute should not be read to extinguish a common law claim to a title and a real property. The most odious of these cases is Prigg v. Pennsylvania, in which the court held unconstitutional a Pennsylvania law prohibiting enslaved people from being taken out of the state and returned to slavery. Good. Wait, what? Wait. The court held unconstitutional a Pennsylvania law prohibiting enslaved people. Oh, that's bad. That's not good. But I guess if you count slaves as real property, it's constitutionally proper. Although the opinion focused on the effect of the Fugitive Slave Act of 1793, the U.S. Constitution's Fugitive Slave Clause, the court also adverted to the common law right of a slave owner to seek a remedy for the wrongful detention of enslaved people. But even in less significant cases, counsel argued that statutes implicating property rights should be strictly construed. Sorry, when I initially read Prigg v. Pennsylvania, I thought it was a pro-abolitionist kind of idea. These first two categories of cases were the ones that occupied the field for the vast majority of the 19th century. Prior to the Reconstruction, the court also invoked the canon, though rarely, in a third kind of case, which also implicated reliance interests. Those in which the statute interfered with common law rights of actions during this time. The court never even hinted, let alone held the common law defenses as incorporated into the statutory clauses of actions absent express legislative direction. To the contrary. Indeed, though not concerning an affirmative defense, United States versus Stansbury is an early example of the court declining to incorporate a common law barrier to relief even where Congress was silent on the issue. The case involved the action of debt brought by the United States against the debtor and his two sureties. The United States had agreed to release the debtor from prison pursuant to a statute that authorized the Treasury to discharge a debtor from imprisonment upon receiving a conveyance of the debtor's estate for the benefit of the United States. At common law, the voluntary release of debtor from a custody constituted a release of the judgment itself, meaning the creditor could not seek a remedy from the surety of the released debtor. The surety in Stansbury argued that given the United States had voluntarily released the creditor from custody as a matter of common law, the government was barred from proceeding against the sureties. The court rejected the argument because the statute's language made clear that its purpose was to discharge the debtor from custody, while the judgment against the debtor remained valid and capable of being satisfied in the future. That the statute was silent as to the common law's treatment of the surety was of no moment, especially because the common law rule was occasioned by a technical rule originating in remote ages, which was never been applied to a statutory discharge of the person. So if you're jailed, it would make it hard to collect from a person who had their properties seized by the government, though. While one can find stray comments in the court's decisions that caution against presuming a statute makes an alteration in the common law further or otherwise than the act explicitly declares, these did not arise in the context of common law defenses, but in the context of claims or rights that existed at common law. The Supreme Court's 1834 decision in Wheaton v. Peters, in which the court rejected the argument that a statute had a discernible impact on a common law right, was to this effect. This is a context in which the court's general language that statutes are not presumed to make any alteration in the common law or otherwise than the act expressly declares. This is the context in which the court's general language about originated. The court was unwilling to read a statute to restraining a thing which the courts described interchangeably as a right that exists at common law absent express language. The rationale lines up with the case law of the time in that it recognized the reliance interest implicated when a statute interferes with a res, be it property or cause of action. Defenses, by contrast, were not conceived of as rights deserving of protection from derogation. In the late 19th century, cases arising both during and after Reconstruction, the Supreme Court's derogation canon cases increasingly arose in this third setting, those involving the relationship between statutes and common law rights of actions. The issue usually presented in either two forms. Cases in which a defendant alleged that the statute had that operated to displace a common law claim, or cases in which the parties interpreted statutes that created remedies and rights of action. Displace a common law right, claim, or... As to the first, the court relied on the canon to generally preserve canon or common law claims for relief. In the absence of express words to the contrary in the statute, illustrative of the approach to the common law rights is Meister v. Moore, where the court held that the marriage was valid even though it was not solemnized before a minister or magistrate, as required by Michigan law. The court noted that at common law, marriage is a contract between that can be formed per verba de presente. I guess that means 4 words to present, or 2 the words of a present party or something like that. By words of the present tense. By words of the present tense. And that if a statute is to take away a common law right, it must do by plain expression. In court's view, a statute that merely directs marriages to be performed in the presence of a certain people should not be construed to be a declaration that no marriage is valid unless performed in this way. In 1879, the Supreme Court applied the canon along the same lines in the context of the rights against misappropriations of personal property other than money. And shall the statute in question had made bills of lading negotiable in the same manner as bills of exchange. One of the parties maintained that his abrogated common law rights of action for misappropriation of personal property. The party argued that a purchaser of a bill of lading for cotton had a right to cotton even if the purchaser had reason to believe that the seller did not have the right to sell it. In the actual case, the bill of lading had been stolen from the bank, which was the legitimate holder of the bill of lading. But the court rejected that contention based on the derogation canon. The court held that simply because the statute treated bills of exchange and bills of lading similarly for purposes of negotiability, it did not follow that they should be treated as the same for all other purposes, namely rights that arose out of the misappropriation. Cases like Shaw and Meister are consistent with the pre-1871 case law involving statutory displacement of common law rights or property interests. While these cases signify the court's concern that statutes not unduly undermine pre-existing rights, they do not speak to the derogation canons. Relevance to the common law defenses, which did not implicate reliance interests As the Supreme Court explained in 1885, when it held that a statute of limitations defense was not a property right protected by the 14th Amendment, even if the most liberal extensions of the meaning of property could be included chooses in action or incorporeal rights, property could not encompass defense to pay a judgment. The Supreme Court explained in 1885 held that the statute of limitations defense was not a property right protected by the 14th Amendment. Oh, okay. Cases of the second sort involved the relationship between statutes and common law, where a statute created a new type of right for enforcement. The court initially vacillated. The court initially vacillated. Alternate or waver between. Okay, indecisive. Between the canon that remedial statutes should be broadly construed and the canon that statutes that enforce a right unknown to common law should be followed with strictness. An example of such strict construction can be found in Ross v. Jones. There, the court applied the canon in the context of remedies against endorsers of negotiable instruments, noting that remedies of statutory character where the right to be enforced was unknown at common law are to be followed with strictness, both as to the methods to be pursued and the cases to which they are to be applied. Ross's logic could arguably apply to Section 1983, given that it also created a right unknown to common law, but nothing in Ross suggested that strictly construing a statutory right encompasses incorporating common law defenses. 15 years after Ross, however, the court adopted a more liberal frame in interpreting remedial law. Everything is to be done in advancement of the remedy that can be done consistently with any fair construction that can be put upon it. Section 1983 would appear to secure in its status as a remedial statute meant to be construed broadly. As Michael Sinclair summarized the relevant jurisprudence, if the statute is not seen as imposing a restriction or a right or duty on the common law, but as fixing to cover a new situation or on otherwise unforeseeable problems, then it is remedial. Construing remedial statutes liberally meant that Sutherland's words, to give effect to it according to the intention of the lawmaker as indicated by its terms and purposes, Section 1983 was enacted as part of a transformative moment in the United States, hardly an example of reinscribing common law principles. Minty. See a fire and ice, it's minty. To sum up the Supreme Court's use of the derogation canon up until and contemporaneous with the Reconstruction Congress betrayed no suggestion that it would incorporate common law defenses into new statutory causes of action, absent express legislative direction to the contrary. If we take seriously the court's declaration that its interpretation of Section 1983 is guided by the understanding of the Reconstruction Congress when it enacted the statute, it follows that the court should not rely on the derogation canon that legislatures at the time would not have expected to apply to Section 1983. And I don't know if this is the last of it. So I'm at 228. All right, I will forego, if time crunches, the derogation canon. So this is one page, this is page 2, this is page 3. And section B goes for about 6 pages. I will skip part 2 for now. Get derogation canon, section C, moved to part 3. Because I want to get to the lost text of the section. All right, section 3, or part 3, the lost section of 1983. The Supreme Court section 1983 immunity jurisprudence has another failing, however, for even if the derogation canon is viable and applicable to remedial statutes like section 1983, it is something of a clear statement rule. Common law should not be displaced by statute, absent explicit command by the legislature. But as I will show in this section, the Civil Rights Act of 1871 did explicitly abrogate common law immunities. Although the relevant text was never included in the codified version of the section 1983, the omission was a part of the first revisor of the federal statutes unauthorized alteration of positive law in the first version of the revised statutes in 1874. What's more, accounting for the original text of the section 1983 makes sense of the legislative history and overall framework of the Civil Rights Act of 1871. The court's flawed immunity jurisprudence, by contrast, directly conflicts with those elements of the law. Section A. The Civil Rights Act of 1871's abrogation of common law defenses. The version of section 1983 one finds in the U.S. state codes, or United States Code, appears silent as to any common law defenses. Every person under color of any statute, ordinance, regulation, customs, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States. Yeah, this is basically what's in that article. But the Civil Rights Act of 1871, as enacted, contained additional significant text, which I will call the notwithstanding clause, in between the words "I shall and be liable." So, shall and be liable. This right here. The statute, the following clause, contain the following. The statute contained the following clause: any such law, ordinance, regulation, custom, or usage of the state of the contrary notwithstanding, and it is a fair inference that this clause meant to encompass state common law principles. Senator Allen G. Thurman, speaking in opposition to Section 1 of the 1871 Act, that is now Section 1983, clearly understood that custom or usage was equivalent to common law. In 1813 to 1894, senator for Ohio. In other words, the 1871 Congress created liability for state actors who violate federal law, notwithstanding any state law to the contrary. One also might think the Supremacy Clause would implicate qualified immunity when state law, common law immunities are applied to bar Section 1983 relief. The Supreme Court has addressed that the potential conflict by pointing to the special federal policy considerations that supported qualified immunity, some scholars dissatisfied with this explanation have offered a different account. See James S. Liebman and William F. Ryan. Some effectual power, the quantity and quality of decision making required of Article 3 courts suggests that the supremacy clause issues are not raised by qualified immunity because unconstitutional conduct by state officials is not the equivalent of state law, and thus does not threaten the supremacy of federal law. Neither the Supreme Court nor its scholars, critics have ever grappled with the significance of the notwithstanding clause for the court's immunity jurisprudence. Its implications are unambiguous. State law immunity doctrine, however, has no for the court's immunity jurisprudence. Its implications are unambiguous. State law immunity doctrine, however framed, has no place in Section 1983. On its face, the clause directly undermined Pearson, which incorporated good faith immunity into Section 1983 based solely on Mississippi state law. Wood v. Strickland, which expanded Pearson's qualified immunity to school board officials, also leaned heavily on the state law immunity doctrine. And before I continue, and while I'm in a mood and I know I'm in a flow and I should not disrupt it. However, I will go and do this for you guys. Go to the Dragon's Treasure. I've been drinking tea, only partially because I've been reading and I have time that I need to kill before mindset gets on. And so I was trying to burn through it, and hopefully I will get through the lost section. However, the lost text section. However, I will say the Dragon's Treasure is a fantastic tea. I am trying the tea of ice and fire. I knew it had spearmint in it because I could smell the mint, and it was an ice and fire thing. This is basically hot and cold rub for your mouth, and it tastes damn good. I will admit, I don't think the minty flavors are my favorite. I'm not opposed to them. However, I will not dislike them or talk bad about them. And I realize I need to do something before or whenever Mindset gets on the show. So remember, go to Dragon's Treasure and use code Layman. You can find it in the description below. And use code Layman for 10% off your purchase. It'll give you savings, fantastic savings with fantastic tasting tea. While I'm not personally biased towards any of the minty flavored ones, they still taste good, and I would highly recommend them to anybody who likes a minty taste. So remember, use code Layman at Dragon's Treasure at checkout for 10% off your purchase. This is not to say that every common law immunity recognized during the 19th century was a creature of state law. The court's opinion in Tenney, for example, canvassed British tradition as well as federal and state constitutions to conclude that that legislative immunity was deeply enshrined in common law. But the vast majority of immunity doctrine, to the extent it existed at all, was sourced in state law, especially for the state actors who would be subjected to Section 1983 liability. To the extent the Reconstruction Congress even contemplated that these defenses would apply to Civil Rights Act of 1871, the notwithstanding clause would have sufficed to assuage those concerns. Notably, the distinction between Section 1983, as enacted, as reflected in the United States Code, is not the product of any positive lawmaking. And that's that notation, 238, see Hogg stating that revisers' changes were not intended to alter the scope of Section 1983. The revised statute of the United States preface saying that reviser had no authority to make substantive change, and act provided for the preparation and publication of the new edition of the revised statutes to the United States. since the revised statutes are considered legal evidence of law but not conclusive. Ah. Rather, the version of the statute we find in any law library today is a product of a decision by the first reviewer of federal statutes to, for unclear reasons, remove the italicized language when the first edition of the Revised States of the United States was published in 1874. Although, and this is another footnote, see, because of complaints about the accuracy of the 1874 revised statutes, Congress authorized the appointment of a new reviser to prepare a second edition of revised statutes, which was published in 1878. The Revised Statutes of the United States, see Library of Congress, and I will just open this here. See the revised Library of Congress version of the revised statutes contained the same error as the 1874 version with respect to what we know as Section 1983. Although the revised statutes were supplemented and corrected over time until the first United States Code was published in 1923, the reviser's error in omitting the notwithstanding clause from the reported version of the Civil Rights Act of 1871 was never corrected. You know, as a side note, for a moment, just take a small second. I'm actually pretty excited for Rumble to add mobile rants. Because, you know, I'm pretty sure most of my views are mobile users. So it'd be nice to see them. And also, I am pumped for election season. I'm really hoping I could profit a little bit off of it. The many errors contained in the first version of the revised statutes prompted consternation, but they nevertheless constituted legal evidence. Consternation is defined as feeling of anxiety or dismay, typically at something unexpected. But they nevertheless constituted legal evidence of federal law. Congress made clear that subsequent versions of the revised statutes can be taken only as a prima facie evidence of the law, which can be rebutted by pointing to the originally enacted version unless Congress has specifically adopted the codification as part of the laws of the United States. Thus, generally speaking, when there is a conflict between the law as codified and the statutes at large, the statutes at large control. Because the first revision, erroneous as it was, is not subject to this limitation, this notwithstanding statute is not formally positive law. However, it still speaks powerfully to the Congress's intent that any immunity grounded in state law has no application to the cause of action we know as Section 1983. Wait, hold on. 1983. Civil rights cause. Why did my brain not connect this until now? If the state actor uses the legal system to deprive a person of their rights, of their constitutional rights, the person may have cause of action for legal actions against them in the form of civil rights lawsuit. 42 U.S. Code. I'm retarded. The notwithstanding clause in the Civil Rights Action of 1871's history and structure. Taking account of notwithstanding clause has another virtue. It provides a more coherent action account of Section 1983 than the Supreme Court's immunity jurisprudence. Starting with legislative history, it is nearly impossible to square the Supreme Court's case law with contemporaneous statements made by the Reconstruction lawmakers. Even as to absolute judicial immunity, there is overwhelming evidence that members of Congress were quite conscious of the fact that both civil and criminal civil rights statutes would displace any judicial immunity. As the plaintiff in Pearson pointed out, President Andrew Johnson vetoed the Civil Rights Act of 1866 in part because it subjected state judges to criminal liability for civil rights violations. Congress responded by reenacting the act and specifically stating that judges may be criminally liable, and it is well accepted that the remedies provided in the 1871 acts were meant to work in tandem with the 1866 act. Notably, when Congress turned to debating the civil liability components of the 1871 Civil Rights Act, opponents of Section 1983 liability explicitly objected to its imposition of liability on judges and other state officials for a mere error of judgment. These opponents understood the officers who make discretionary decisions would be held liable under Section 1983, notwithstanding their good faith. That was precisely why they opposed it. None of the proponents spoke a word of assurance, leaving the implication that opponents had accurately understood the legislation. This history, in combination with the absence of any language in 1983 regarding immunity, offers a strong indication that Congress meant to abrogate all common law immunities, even without the notwithstanding clause. Additionally, the legislative record is replete with evidence that supporters of the Civil Rights Act did not trust the state courts to protect constitutional rights. The government itself is saying that they don't trust themselves to protect constitutional rights. Well, of course, it's state courts, but of course, you apply the state courts to the federal courts. It's kind of a laughable hypocrisy. However, if Congress or the legislative record has evidence of them being skeptical of state rights, of protected constitutional rights, then I would certainly look at it in a very, I would look at it favorably, because, the Reconstructionists, barring their failures and shortcomings and all that we might say about the war, Northern aggression, and whatnot, I think forcing some states to apply federal rights that should have been protected in these cases, if a constitutional amendment says, free the slaves, and they, don't free the slaves, I would probably put an assurance in place to absolutely secure that. Some of the very same people who served in this rebel army were also serving as judges in southern states. It would have been passing strange then for the very same Congress to permit liability under Section 1983 to be limited by a judge-made law created by state courts judges, as Seth Kramer has argued, given the civil rights actions proposed to disarm a Confederate state judiciary hostile to Reconstruction. It seems unlikely that the local common law elaborated by the very judiciary that the federal courts were designed to supersede was to be given primacy. The notwithstanding clause thus both reflects and confirms the 1871 Civil Rights Act history and purpose. The interpretation of Section 1983 has ample support in the courts, at least for the first half of the 20th century, when it was common for courts to apply Section 1983 free of any state law immunities. Prior to Pearson and Tenney, even the Supreme Court had affirmed damages awards against state officials on multiple occasions without any mention of common law immunity doctrine. The Supreme Court's 1961 decision in Monroe gave even more support to those who would read Section 1983 as imposing liability notwithstanding any state law defenses. Indeed, as one post-Monroe opinion noted, if a state law immunity displaced liability under Section 1983, it would be inconsistent with Monroe's basic holding that the availability or unavailability of state law remedies is irrelevant to the relief afforded by federal law. Excavating the notwithstanding clause also sheds additional light on the relevance of 42 U.S.C. subsection 1988, which authorizes district courts to fill gaps in the Civil Rights Act with state law under certain conditions. And these conditions, 257, whatever the value of nationwide uniformity in areas of civil rights enforced where Congress has not spoken, in areas in which 1988 is applicable, Congress has provided direction indicating that state law will often provide the content of more federal remedial rule. Section 1988 provides authority to look to principles of the common law as altered by state law so long as such principles are not inconsistent with the Constitution and laws of the United States. The court will deem a state law inconsistent with Sections 1983's broad remedial purpose simply because it interferes with a remedy in a given case. The state law must be inconsistent in a more general way to be precluded by the exclusionary language of Section 1988. Section 1988 has been applied to determine what measures of damages to use, what rules of survivorship apply, and which statutes of limitation to use. In short, it constructs courts as a choice of law in actions brought to enforce the substantial provisions of Civil Rights Acts. Some scholars have grappled with whether Section 1988 gives courts authority to rely on states' common law immunity, but the proviso, a condition attached to an agreement, gets provision. In Section 1983, omitted by the reviser, answers the question more directly. State law, which imposes a barrier to Section 1983 liability, was not meant to apply under the proviso. While state law that makes Section 1983 more effective should be applied under Section 1988, because the Supreme Court's qualified immunity jurisprudence is and always has been inconsistent with this concept, and it cannot be squared with the text purpose or context of the Civil Rights Act of 1871. This conflict persists whether immunity doctrine is the common law version announced by court in Pearson or the form adopted by the current court, requiring that a plaintiff show a violation of clearly established law to establish Section 1983 liability. I know I'm supposed to have mindset on for Disney, but I think I'm gonna spend like the first 10 minutes talking about this in some way. I want to tell him about it. I don't know if he knows. Implications and objections. Putting Section 1983 into interpretive context and accounting for the enacted text of the Civil Rights Act, thereby minimizing the relevance of the derogation canon and putting state law immunities on the sideline where the Reconstruction Congress intended, has many significant implications. First, unlike the scholarship and advocacy that urges the Supreme Court to read Section 1983 as limited by the 1871 understanding of common law immunities, This article shows that any such immunities have no place in Section 1983 litigation. This is decisive as to the good faith immunity that the court has transformed into qualified immunity, to the extent that this immunity exists as a creature of state law in 1871. The Reconstruction Congress made it clear that it has no place in federal civil rights claim. Moreover, Pearson itself relied only on Mississippi law to support a good faith defense to Section 1983. Thus, Pearson was and always has been inconsistent with the Civil Rights Act of 1871. Some might argue that even if state courts' opinions were the source of the 1871 version of immunity defense, the common law was neither federal nor statute in the era of Swift v. Tyson. If so, the argument goes, and I guess Swift v. Tyson is was a case brought in diversity in the circuit courts in for the Southern District Court. The trial court applied New York common law, held that Swift isn't a bona fide purchaser, and entered a judgment for Tyson. The Supreme Court accepted the case. Oh, I think this is what was mentioned before. If so, the argument goes with notwithstanding clause is less. The notwithstanding clause is less relevant because common law immunities could not exist independent of whatever state law was abrogated by the Civil Rights Act of 1871. This argument overlooks the fact that even under Swift, there was a critical distinction between general law, which knew no sovereign, and local or customary law, which was considered state law. Swift's general law was applied in cases involving commercial relations, or in tort cases involving interstate commerce. Unsurprisingly, these cases all involved railroads and arose in the late 19th century. Outside of these laws, state law, whether statutory or judgment governed, questions of public policy as affecting the liability for acts done within one of the states of the Union, unless controlled by the federal law or by considerations requiring national uniformity, such as commercial relations. More pointedly, cases involved in the tort liability of cities and states involved local law according to the court, making a state court decision on such matter dispositive for the purposes of federal courts. Thus, even in the Swift era, the notwithstanding clause, along with the legislative history and overall purpose of the Civil Rights Act, should be read to displace local common law immunities. Even if objectors find a way to minimize the notwithstanding clause displacements of state law immunities, advocates for immunity doctrine still must show why the derogation clause should be applied. Commercial relations is like prostitution. Or are you? Even if the objectors find a way to minimize, derogation should be applied in such a novel way as to incorporate common law defenses into Section 1983. Given what any reasonable legislature would have understood about the canon in 1871, as discussed above, by 1871, the derogation canon was on insecure footing and had never been relied upon as a basis for incorporating a common law defense into a statutory cause of action. Nor does post-Reconstruction jurisprudence regarding the derogation canon rehabilitate the court's Section 1983 immunity doctrine. To be clear, these insights have implicated beyond qualified immunity. have implications beyond qualified immunity. The availability of legislative, prosecutorial, and judicial immunity in Sections 1983 litigation are all grounded in a flawed application of an already unsound derogation canon. To be sure, these implications are uncertain because there may be independent grounds for retaining certain immunities. After all, Congress has arguably endorsed judicial immunity through its amendments to Section 1983, and legislative immunity is based on more than simply common law principles. Prosecutorial immunity, however, has some of the same failings as qualified immunity doctrine. It is premised on common law doctrine, principally state law, which has no place in Section 1983. A second implication is that because this article's interpretations of Section 1983 rest on the Civil Rights Act's enacted text and existing modes of interpretation, effectuating it does not require any action by Congress, some might object that the current court would be resistant to reversing long-withstanding precedent, especially in the light of so-called super stare decisis of statutory interpretation. Second implication that because articles of interpretation in Section the Rights Act enacted and existing modes of interpretation, effectuating does not require an act of Congress, some might object that the current court would be resistant to reversing long-standing stare decisis. But the court's misstep here is that it has entirely failed to grapple with the Civil Rights Act's enacted text. Moreover, notwithstanding the rhetoric that stare decisis is amplified in area of statutory interpretation, the court has often disregarded the presumption against overruling, albeit with varying degrees of transparency. Presumption against overruling. By one count, the court overruled statutory interpretation cases 80 times in the span of under 30 years. The court overruled Swift v. Tyson nearly 100 years after it was decided, notwithstanding congressional silence in the interim. Monroe v. Pape was overruled in part 17 years after it was decided over the dissenters' criticism that Congress had taken no action calling Monroe into question. Pearson's error is at least as egregious as Swift's or Monroe's, and it has spawned an immunity doctrine that has created significant instability and garnered well-founded criticism. Third, there are significant practical implications that flow from the arguments presented in this article. When qualified immunity applies in litigation, it bars all compensation for victims of unconstitutional conduct. No matter how egregious or injurious, these cases run a gamut from school officials who receive qualified immunity for subjecting teenage girls to invasive strip searches with no reasonable basis, to police officers who receive immunity when they use deadly force against unarmed citizens, to corrections officers who are aware that an incarcerated person is suicidal and watch without intervening as he wraps the phone cord around his neck and dies by suicide. Qualified immunity also has a harmful systemic impact because courts are free to apply the doctrine without ever considering the underlying merits of the plaintiff's legal claim, making it difficult for constitutional law to change over time. And because it looms over every potential civil rights case, there is a good reason to think that the doctrine deters injured people from initiating litigation or interferes with their attempt to obtain representation. Removing qualified immunity would thus result in more compensation for constitutional misconduct, more development of constitutional law, and likely more civil rights litigation overall. Not everyone would view these as positive developments. Talk of floodgates and other adverse consequences running through the debates about civil litigation in this country. Although many of these concerns lack empirical foundation, it would be fair to presume that removing a defense, even one that does work in small minority cases, will result in greater litigation and larger recoveries for plaintiffs. Whether this is a future or a bug depends on normative judgments about the role of litigation in fostering law-abiding behavior. The other barriers that exist to prevent litigation abuses, the actual costs imposed by changing course, and costs of maintaining the status quo, there are good reasons, however, to think that eliminating qualified immunity will reduce inequity and improve the administration of justice. And as this article has shown, eliminating qualified immunity would be consistent with the actual text enacted by the Reconstruction Congress. In conclusion, the article raises a legal version of the popular philosophical question about the tree falling in a forest. If the legislator enacts a statute but no one bothers to read it, does it still have interpretive force? Section 1983's immunity jurisprudence can only survive if the answer to this question is no. But for the reasons outlined in this article, Section 1983 should be read and applied in light of its original enacted text. The Reconstruction Congress intended to create liability, notwithstanding contrary state law, meaning that state law immunities have no place in Section 1983. And derogation canon, to the extent it applies to all Civil Rights Act of 1871, cannot be the basis for applying some other common law defense of qualified immunity. If the Supreme Court continues to apply its qualified immunity doctrine to Section 1983 claims, its mistakes go beyond the well-grounded criticism others have raised. For as this article shows, the court's immunity jurisprudence has not just used freewheeling judge-made law to fill a gap left by the legislature. Instead, it has deployed a canon of statutory interpretation founded on a mistrust of legislatures in favor of supposedly greater judicial wisdom. To apply Section 1983 in a way that contradicts text adopted by the Reconstruction Congress, compounding one grave error with another, the Supreme Court has created an immunity jurisprudence that departs from the text's purpose and context. You're talking about Castle Rock v. Gonzalez in that first one, which might be true. Castle Rock v. Gonzalez. Gonzalez requested, okay, so the case was she had a restraining order against her estranged husband, and the restraining order was in fact, but it might be confused about it. In a 7-2 decision, the court ruled that Gonzalez had no constitutionally protected property interest in the enforcement of the restraining order, and therefore could not claim that the police had violated her right to due process. It's a due process thing. I guess I should probably question qualified. In benefit as abstracted as enforcement of the restraining order, the court ruled Gonzalez would have needed a legitimate claim of entitlement to the benefit. The opinion of Justice Antonin Scalia found that state law did not entitle the holder of a restraining order to any specific mandatory action by the police. Instead, the restraining order only provided grounds for arresting the subject of the order. The specific action to be taken is up to the discretion of the police. The court has stated that there is no sort of entitlement out of which a property interest is created. The court concluded that since Colorado has not created such an entitlement, Gonzalez had no property interest. The due process clause was therefore inapplicable. Justice John I think what you might be thinking about is more along the line of Uvalde. I guess we'll look at Uvalde officers. God damn. That is a good question, though. Not responding is... Not responding is not the same as... Unfortunately, is not the same as qualified immunity standards. Not responding is not... I'm just going to say the same thing over again, I realize. The context for the school people were the strip searches of students. And I guess if it becomes overruled, it will now be used to make the person civilly liable for the violation of constitutional rights, like shutting people up in the school board meeting. School board members and police officers who may have taken their duty too far and reached beyond it, the whole color of law thing. It has to be in their duties. Not responding to a crime is not the same, unfortunately. And besides, don't you know that you could just you could find them later and catch them? God, that... All right, section C. Derogation. 228. The twin... But one round goes... Okay, so... And robbers get away. Oh, so like 10 bank robbers robbing a bank and actively shooting everyone inside. One cop who's a bad shoot runs in, saves the day, begins with shooting all 10. But one round goes astray and hits an innocent person. One of the cops' rounds hits an innocent person. That would go to self-defense. Well, they have no duty to retreat or no duty to respond. They're also law enforcement agents, and if they respond to a deadly threat force, which is a bank robbery of people aiming guns at people, yes, because the intent of immunity for the self-defense would apply to the cop with every shot fired that was intended to neutralize or end the criminal act, the deadly force threat criminal act of every robber. It's why Rittenhouse was acquitted of the shot that put, what's his name? Gavin McInnes in danger. Is it Gavin McInnes? Gavin Mc. No. Rittenhouse. Gavin. Rittenhouse. Trial. Gavin. McGinnis? Richard McGinnis. My bad. My bad. I'm sorry. Hold on. Is this law and crime? Oh, these faggots. Well, not only was the cop doing his duty under color of law, he was also shooting to save everybody else. Whether shooting to save everybody is prudent due to an approach of, you know, when someone shoots their first shot, everyone else is going to start going crazy. The cop is, of course, having to, well, without qualified immunity, would not have the good faith requirement, and their actions could be deemed unconstitutional. However, the officer's defense in this case would just simply be a self-defense case. An endangerment charge against, or the endangerment of the other person, or the it wouldn't be endangerment, or it would be endangerment against the citizen, reckless endangerment, or reckless manslaughter. Because we know from the Potter trial that prosecutors really do love charging their officers with, you know, reckless manslaughter. I'm basically done with this. Here, I'll read the civil rights thing to you. So here's what the civil rights cause of action is. Every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia subjects or causes to be subjected any citizen of the United States or other persons within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit, in equity, or other purposes for proceeding for redress. Of course, this also goes and says, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding. So basically, right here, cuts off common law. Qualified immunity. I guess if I had to pull up a quick lookup. Protects the government from lawsuits alleging that the official violated a plaintiff's rights. Only suits where officials violated a clearly established statutory or constitutional right. It's a very high bar. This is a very high bar to reach. You basically never get there. What qualified immunity is an affirmative defense, or an affirmative common law defense. in which derogation canon was used. However, the derogation canon was used only in common law claims, so like property interest and whatnot. It cuts that basically for all state actors. Subjects or causes to be subjected any citizens of the United States or other person within the jurisdiction thereof to be to the deprivation of any rights, privileges, or immunities secured by the Constitution shall be liable. Honestly, this should also, I think if this law were to apply, it would also apply to federal actors as well. Not so like FBI, CIA, NSA, that such group. They would also be liable for the damages that they cause in their actions. Hot damn. My understanding is that qualified immunity to foreign government of diplomats. My understanding is that it doesn't necessarily have to be government actors, like the U.S. government. Well, that sounds like diplomatic immunity. Diplomatic immunity. Diplomatic immunity is a status granted to a diplomat that exempts them from laws of foreign jurisdiction. It must be noted that immunity is a privilege of the state that a diplomatic agent represents. As such, a person cannot allege breach of immunity if the state does not contest the violation. Oh, did you forget the phrase of diplomatic immunity? Oh, I know what I should do. Oh, what the fuck? I'm not gonna make fun of you, though it is pretty funny, I will admit. I I was reading and I'm like, that sounds like diplomatic immunity. All right, see you when you get back, man. Oh. All right. Sweet. Oh. Testing, testing. All right. So I guess I just gotta fill in time until mindset gets here. Huh. Reload. Reload. So it has been interesting learning about the derogation canon. I guess before he gets here, since I think I'm on second hour in. Oh no. I would be if my stream didn't fuck up at the start, basically. Causing me to be late. Oh shit. Oh shit. Look at that. I got a new subscriber. Hell yeah. Let's see here. Are they still going? Okay. Here, I will introduce myself. Unmute that tab. All right, with the derogate rather qualified immunity thing undone. I will start up my research again back into Disney. And I'll see him when he gets here. Let's go. Oh wait, it just go to my bookmarks. Wait. Go to camera. Sidebar. Other bookmarks. Uh-oh. This is bad, this is bad, this is bad. Oh man, this is bad. 2 hours. It's just 2 hours. Maybe. Maybe even less. So current versions of 8.0 website is not associated with any manner whatsoever with the Walt Disney Company, its subsidiaries, and/or its affiliates. Collectively, Disney. The purposes of the site is to present a complete and independent presentation of Epcot as imagined by Walt Disney in the 60s, and as a personal exercise in online journalism. Marty Schuyler, Rebecca Carlton, Jeff Williams, and Walt Disney Imagineering. Okay. Also, Airline. airplane page. Live viewer comments show up on StreamYard's example. I will admit the whole Cult-sided music thing has pulled me out of the whole Disney project I had in mind. However, I will power through it and I will figure it out. What the hell? Powerade. All right. Oh wait, god damn it. And here I thought I had moved the focus. There we go. So I covered the overview, the introduction, and the master plan. Then I went over the chronology, I believe. So Walt Disney is born in Chicago, Illinois. Walt Elias Disney. Enterprises to carry out planning for building the Disneyland. Disneyland opens in Anaheim on live TV. MIT designed Monsanto House of Future rises in Tomorrowland, showing Walt Disney's interest in his future in his park, using his park to influence real world architecture. November, Walt and a chosen group of confidants scout a tract of central Florida swampland called the Reedy Creek Basin. The New York World's Fair opens. I think I've read this before. Walt Disney's tasked with his team with producing a film written by Marty Schuyler A model primarily designed by Marvin Davis based on a concept art by Herbert Ryman in order to promote Epcot, the city, to the Florida legislature, to Ryman's artwork. What the hell? All right, so back to it. In order to promote the Epcot, the city, to the Florida legislature, Ryman's artwork, as well as the unfinished centerpiece of the model, the Epcot Hotel, is featured in the film. After a highly successful 2-year run at New York's World Fair, GE committed to continuing sponsorship of Walt Disney's Carousel of Progress at Disneyland. Wait, hold on. After Walt's death in 1966, however, hopes for building a city in Florida diminished, but it was decided that the model should be completed anyway by a team led by John Frank. Member of the team included Roger Bragi Jr., Neil Gracie, Georgia Wyndham, and many others. And that fucking qualified immunity thing took a whole lot of my steam. At the fair, GE operated a post-show attraction where their products were presented in a mock city environment called Progressive City. And when the carousel opened at Disneyland in 1967, it was still too early to pitch the Epcot community Walt had envisioned. So the decision was made to display the complete model to guests exiting the attraction. It was here that the Epcot model was renamed Progress City. Oh, God. My viewership's gonna plummet right now, but I need to go. Hey, I'll be back. Hopefully in like not so long. I am going to brown my pants. So I'll be back. I return slightly less shitted than I was before. Okay. I'm getting nervous. Oh, I'm getting nervous right now. Holy shit. I've snacked, but some of my snacks are blondes and brunettes. Giggity. I got it. Walt Disney, or like Walt Disappointment. Or like Walt Disappointed. His whole fucking vision was chopped because he died. Since 1975, following the opening of Walt Disney's Magic Kingdom in 1971, Marvin Davis circulated a memo dated August 1972 in an attempt to get the Epcot project moving again. Davis's efforts, along with urging from the GE, who sought to reinvigorate the show by attracting a new East Coast audience, resulted in the carousel moving to Florida, along with the Progress City model. John Olson recalls being shown the model of the Jimmy Elliott in 1974 while it was in storage, awaiting transport to Florida. I'm out of tea. You know, that's the problem with the sample packs I drink. There's only so much of it. And the pitcher makes about half the thing. However, it doesn't because it has so many. Here, I'll just copy pasta. There's also good enough time as any to reintroduce and no. So the Dragon's Treasure, Heaven for Anime and Tea Lover. So like I was saying, so it's got 1 tablespoon per 8 ounces. That's very close. This is an 8 ounce. So and I can rebrew this up to 1 to 2 times. So either 16 ounces or 24 ounces. And that's only like, this cup is a lot more than 8 ounces. Also, Huh. Yeah, the Dragon's Treasure is a haven for anime and tea lovers. And if you're watching along and enjoy tea or even coffee, I think that might be that's going to be added sometime soon. Definitely entreat yourselves to some tea. It is fantastic. And remember to use code Layman. Wait, oh shit. And use code Layman at checkout in this little area right here for 10% off your purchase and enjoy fantastic savings with fantastically flavored tea. I have to say, with the Fire and Ice, I'm not too keen on the taste. I've either lost my taste for spearmint or some kind of peppermint, or it's not peppermint, and I'm just really enamored with cinnamon flavors now. I like super sweet tea. Is cinnamon sweet though? The butterscotch was good. The butterscotch, jasmine lemon pepper, wizard beer. Tea of Fire and Ice. The Tree Folks Forest wasn't so bad. Not my preference though. Though it's kind of hard to brew because it's got like a boil for 1 to 3 minutes, but like the boil options are 5 to 7 minutes on the kettle. It requires some control. But remember to use code Layman at checkout for 10% off all your purchases. That relates to everything on the store. Dragon Wings membership, teaware, tea itself, the merchandise. You can get everything from the store for 10% off with code Layman. I think even the tea of the month it will apply to. I either recommend the wizard beer or the butterscotch. Fuck. Oh man. You know, it'd be really depressing if Mindset forgot about me. Walt Disney World's Kingdom in 1971. Yeah, transport back to Florida. When GE elected to forego a post-show area in the Florida park, John Hinch designed a current one-story building featured at Magic Kingdom. Because of this change, however, the Progress City model became expanded, but became expendable. But show was still needed to fill in space along Wedway People Mover track, so it was decided to use the model for the purpose. Unfortunately, though, it had been cut into pieces for its cross-country voyage, and because the entire model would not fit in the new space, much of it was discarded. Since 1975, and the remaining 1,428 square foot portion of the model, including most of the elevated downtown section, about half the greenbelt and roughly one cropped residential area has been on display along with Tomorrowland Transit Authority, Wedway People Mover. Ride path. The Carousel of Progress was one of Walt Disney's attractions developed for the New York's World Fair in 1963 to 1964. Guests stayed in their seats as an outer ring of 6 theaters moved around in fixated circular sections, while guests were entering into one theater and exiting from another. guests in another 4 theaters were watching the tireless audio animatronic actors in the 4 acts of the show, depicting the evaluation of the science and technology evolution. I feel like that should say. And technologies in our lives through the eyes of the same family. When the fair ended, Walt Disney had a perfect attraction to export to Disneyland. Walt Disney died in December 1966. He never saw the July 1967 reopening of the attraction, this time at Disneyland. I did find a typo. After the show, guests boarded a speed ramp, and they found my Speako. That doesn't make sense, but sure. The speed ramp that would take them to the second level of the building. On the upper level, a 4-minute post show narrated by mother and father, with a few barks and growls of their dog, coincided with guests gazing at an enormous model of the Progress City. Progress City was based on Walt Disney's original concept for the experimental prototype community of tomorrow and the Walt Disney World property. Before the 5th act, located on the upper level of the carousel, the 4th level of the show indicated or included a sneak peek of Epcot through the window of the family's living room. Oh! Okay. I thought this model was smaller in scale. I didn't realize that this model was basically, you know, a whole fucking room. Fantastic. What? They could film Godzilla in that model. They absolutely could. Sorry, I distracted myself. Oh, and I gotta make sure I sent in the right one, actually. Yeah. So the city was the preview of Walt Disney's vision for Epcot. Extremely detailed, the model features all the major key elements of his project: the radial design, the urban center and its towering model or hotel, the greenbelt, the industrial park, and the monorails and people mover. Epcot's model was truly amazing: 115 feet wide, 60 feet deep, and 1,400 individual streetlights, 2,500 moving vehicles representing future transportation, 2,000 trees, and 4,500 or 20,000 trees, 4,500 structures, buildings. Disney Imagineer George Wyndham recalled that at Walt Disney's insistence, the interiors of the 1 to 8-inch scale buildings of the original Epcot model, which were barely visible through their tiny windows, had to finish, furnished, and lit. The guests might not notice, but Walt would know the details were there. So even the inside of the buildings looked like they had been designed properly. Epcot models was truly amazing. Yeah. Progress City was truly a model city. The miniature city was built at a scale of 1 to 8 inch, equal to 1 foot. It represents a three-dimensional vision of Epcot, Walt Disney's vision of a model city of the future where people could live a life that they couldn't find anywhere else in the world. Starting in the south, the resort was supposed to contain a jet airport, a motel complex, and an industrial park, including a nuclear power plant. The city lakes and resort area, and the theme park. These complexes would have covered close to a square mile each and would have been located along the spine of the resort's and main highway and interconnecting monorail that stretched almost the entire length of the property. Instead, the smaller versions were created to give viewers a sense of the entire scope. The model contained a small amusement park, but even this tiny amusement park was well thought out and planned. Everything that would be needed for a real amusement park was included. Oh, wait, what? Oh. I am so damn concerned that he might not end up showing up. Or was I supposed to go in with him? I don't know. Well, he said he can only be on for a period of 1 to 2 hours. My intent, and I was hoping to have him on by 7, which was 40 minutes ago. If he could not, I understand, but so at the very least, I might have him for like, I don't know when I'll actually have him at the very least. Oh, did he say anything in the Discord about not being able to come? No. I think mine said probably got caught up with the little Poo-tang pudding. I think he would. I don't think he would get lost in that when there's a. After seemingly accepting someone's invite for show. Man. Hold on. I'm watching a moment. And... Hell yeah. I don't know. Now I'm stressing out. I need to relax. It's not good. I need to take a deep breath. Like, he liked the show, or the link to the show. So I would think. Well, maybe. I don't want to bother him. I mean, I guess if you agreed to come on, it would be fair, but, I mean... Oh, man. I'm just kind of hoping that by the time 9 o'clock rolls around, I'll have talked to him for a little bit at least. It'll be a nice little reunion. Man, I don't know why I'm so worried about this now. God damn. Just relax. It would suck so bad if a guy's showing up or showing off by fucking mindset. Damn. God, I don't want that to happen. It's like it took a it took a little bit of time to even get to this point because like there was a lot of interference. So maybe he has a bit of trouble moving. He could be having trouble moving in right now. That could be the problem. He is, but he agreed to the time frame. We were using Central Standard Time when setting up for this. This is like his evening, I believe. Or his, yeah, it's AM. Uh, I'll stop worrying about it. I gotta get the show on the road. I can't just stop because of, yeah. I have the StreamYard pulled up, so if he jumps in, I can see him. So the urban center is the iconic part of the Epcot included. Here's a symbol of the Epcot Cosmopolitan Hotel built on a recreational deck. The hotel itself has a very contemporary design and surrounded by lower office buildings. The deck is landscaped and several interesting features can be seen. Tennis courts, heliports, running paths, several glass domes providing natural lights to the levels below. The deck is indeed the roof of the enclosed and climate-controlled internal shopping center. This small concept was revolutionary at the time of Epcot's design phase and would have included shops, restaurants, and entertainment based on various cultures from all over the world, much like what eventually became constructed as World Showcase at Epcot Center, the theme park. The urban center. Wait a minute. I just realized I was approaching the wrong thing here. So my whole design of this is to approach the legal matters of Reedy Creek. I'm looking at Epcot. I should be looking at Reedy Creek in the Reedy Creek Improvement District. Right now, it's the Central Florida Tourism Oversight District. I can learn about Epcot later. After the success of Disneyland in California, Walt Disney began planning a secondary park. I think, yeah, I clicked these links as I was going through them. So Walt Disney's envisioned a whole city just based on Disney Entertainment. No, the Reedy Creek Improvement District. The whole point of it was to make a city, a whole city, not just a Disney-based city. The city was supposed to be basically like Fort Worth, Dallas, New York, Manhattan, something like that. It was supposed to be a government, basically, in the middle of everything. It was only supposed to have the Disneyland Park or Disney World Entertainment area far north of the district of the district. It would also have been like one-way accessed into it. He stepped away from entertainment into basically city planning. Yep, basically. If that's an accurate thing. He would have been papal-like, basically. And wanted control of much of the large area for the new project. He flew over Orlando, in which he bought up a bunch of areas. Reedy Creek Tomahawk Properties Incorporated, under a bunch of names different from his own. We all know who the real Pope is. Pope brackets, the law pope. On March 11th, 1966, these landowners all owned subsidiaries of what is now Walt Disney Company, petitioned to the Circuit Court of the Ninth Judicial Circuit, which served Orange County, Florida. Walt Disney knew that his plan for the land would be easier to carry out with more independence. Among his ideas for his Florida project was his proposed Epcot, the experimental prototype community of tomorrow, which was to be a futuristic planned city, which is also known as Progress City. He envisioned a real working city with both commercial and residential areas, but one that also continued to showcase and test new ideas and concepts for urban living. Therefore, the Disney Company petitioned the Florida State Legislature for the creation of the Reedy Creek Improvement District, which would have almost total autonomy within its borders. Residents of Orange and Osceola counties did not need to pay any taxes unless they were residents of the district. Services like land use regulation and planning, building codes, surface water control, drainage, waste treatment, utilities, roads, bridges, fire protections, emergency medical services, and environmental services were overseen by the district. They would have been a government. Okay, yeah. The only areas where the district had to submit to the county and state would be the property taxes and elevator inspections. The planned Epcot City was also emphasized in his lobbying effort. On May 12, 1967, Governor Claude R. Kirk Jr. signed the Reedy Creek Improvement Act, adding following Florida statutes to implement Disney's plans. Created the Reedy Creek Improvement District, established the city of Bay Lake, established the city of Reedy Creek, later named as the city of Lake Buena Vista, around 1970. According to a press conference held in Winter Park, Florida, on February 2nd, 1967, by Vice President Don Tatum, the Improvement District and cities were created to serve the needs of those residing here. Because the company needed its own government to clarify the district's authority to provide services within the district's limits. And because of the public nature of the planned development, the original city boundaries did not cover the whole improvement district. They may have been intended as the areas where communities would be built for residential use. To maintain full control of the district, it was important for Disney to limit the voting rights of the inhabitants, rights which were only meant to include landowners owning more than 1/2 acre. Since Disney owned most of the land, the residents would simply be renting their homes. But after the 1968 Avery v. Midland County case, Disney feared that they would have to eventually give everyone living inside the district voting rights. Though the population was restricted to the two municipalities, Bay Lake and Lake Buena Vista. Further development in 1996 and 1993, the land that eventually became Disney-controlled town of Celebration, Florida, which was built with many of Walt Disney's original ideas. Hold on, give me just a moment. I gotta address something. Back at it? Oh, wait. Not quite back at it yet. No, do not. Damn it, this sucks so. According to the press conference, improvement district cities were created within the districts. In 1993, the land that eventually became Disney controlled, which was built with many of the Disney's original ideas, that had since evolved into a form of new urbanism, was de-annexed from Bay Lake and the district. This was done to keep its residents from having power over Disney by providing for separate administrations of the areas. Celebration lies on unincorporated land within Osceola County, within a thin strip of still incorporated land separating it from the rest of the county. This strip of land contains canals and other land used by the district. Yeah. The Reedy Creek Improvement Act was held by the Supreme Court of Florida not to violate any provision of the state constitution, as the law in part declares that the district is exempt from all state land use regulations now or hereafter enacted. The Attorney General of Florida has issued an opinion stating that this includes state requirements for development of regional impacts, DRIs. After Walt Disney died in 1966, the Disney Company board decided that it did not want to be in the business of running a city and abandoned many of his ideas for the Progressive City. Or for Progress City, rather. The planned residential area was never built. Richard Vogelsong argues in his book, Married to the Mouse, Walt Disney World and Orlando, that Disney has abused its power by remaining in complete control of the district. In January 1990, the RCID was granted a $57 million allocation of tax-free state bonds over an agency with plans for a low-income housing development and all additional government applicants in a 6-county region. As the state distributed the bond proceeds on a first-come order, Disney was criticized for the move, with a Republican gubernatorial candidate filing a lawsuit to stop RCID from using the funds. Also, one state legislator moved to limit the RCID's ability to apply for the program. That is spicy. On March 30th, 2022, State Representative Spencer Roach tweeted that Florida legislature had met twice within the past week to discuss the possibility of repealing the Reedy Creek Improvement Act and strip Disney of its special privileges in the state. Roach and Florida Governor Ron DeSantis later criticized Disney for the special perks the company enjoyed through use of the RCID. Roach said there had been previous attempts to eliminate the district. A bill analysis and fiscal impact statement for the bill was created on April 19, 2022 by Senator Jennifer Bradley. However, this analysis was unable to determine the impact of the bill would have on either the residents served by the special district or the local governments that would absorb the district's debts. At least the Wikipedia page will call it for what it is, and will recognize that critics dubbing a bill saying don't say gay bill is only a dub and not the actual thing. Ugh. Oh, fuck. You sleep well, NC Native. Catch you later, buddy. Thank you for coming to watch. Damn it. Hang loose, buddy. The Reedy Creek improvement. I kind of want to get more of the history of it up until the abolishment. In the mid-1960s, the Walt Disney World Corporation proposed building recreation-oriented, developed on 25,000 acres of property in Central Florida. The property sat in a remote area of Orange and Osceola County, so secluded that the nearest power and water lines were 10 to 15 miles away. Neither Orange nor Osceola County had the services or the resources needed to bring the project to life. In 1967, the Florida State Legislature, working with Walt Disney World Company, created a special taxing district called the Reedy Creek Improvement District that would act like with the same authority and responsibility as a county government. Walt Disney World could then move ahead with its vision to turn 38.5 square miles of largely uninhabited pasture and swampland into a global destination resort that welcomes millions of visitors every year. The new legislation said that landowners within the Reedy Creek Improvement District, primarily Walt Disney World, would be solely responsible for paying the costs of providing typical municipal services like power, water, roads, fire protection, etc. Local taxpayers, almost said taxpayers, meaning residents of Orange and Osceola County would not have to pay for building or maintaining those services. The corporation and commitment between the Reedy Creek Improvement District and the Walt Disney World Company is as strong today as it was when it was created in 1967. The result is an example of how a working partnership between business and government can be prosperous for both sides. Reedy Creek by the numbers. 134 miles of roadways and 67 miles of waterway built and maintained. 250,000 guests, their daily guests. Legendary Lee Candy. Hello, Relish. Nice seeing you. Legendary Lee Candy. What is that about? 6 to 8 minutes response time for fire and EMS. 60,000 tons of waste management. 30,000 tons of aluminum, paper, steel cans, cardboard, and plastic containers recycled every year. 22,800 water samples collected by RCID scientists from 1,500 locations on the property for the testing every year. 90,000 analysis conducted to make sure the water quality meets or exceeds state and national standards. Water draining from the south end of the district is generally cleaner than when it entered Reedy Creek at its north end. 2,000 vendors, suppliers, and contractors used to provide a high level of public service for visitors. That was great. Yeah, that's the last time I'll do that. Sorry if you got blinded there for a moment. They have a RCID administration first floor building, first floor boardroom. Board of Supervisor meetings 2023 canceled. So City of Bay Lake, Todd Wetzel, Mayor, the council member, Mayor Pro Tem, council member Jesse McBurns, council member. I cannot overstate how much the fall of Reedy Creek, as it was in the hands of Disney, feels like the fall of Jerusalem the first time. But instead of 500 years of constant disobedience and defiance of the major authority that presided over it, this happened after like 50 years. Yeah, it didn't last very long. Oh well. Geography, government. Critter Creek Fire Department was created in 1968 to provide fire suppression for RCID. Today, the RCID's RCFD provides fire suppression, emergency medical services, 911 communications, fire inspections, technical rescue services, and hazardous material mitigation. EMS makes up approximately 85% of the call volume, with RCFD providing both advanced life-saving support and basic life-saving support. RCFD currently staffs 4 fire stations located throughout the district with 1,308 personnel across 3 shifts. They also maintain a staff of 86 administrative and support personnel, including EMS team members, primarily located on each of the 4 Walt Disney World theme parks, 1 communicators, fire inspectors, and there are 4 engines, 2 tower trucks, and 1 squad unit, 8 rescue ambulances, and several special units. And here is the Fire Station 4 at the Lake Buena Vista. Oh, man. I honestly don't know where to go after all this. How do I look further into it? Like, it's just city, district administration, board of supervisors. District is governed by 5-member board of supervisors who hold office for a staggering terms of 4 years. For the unique issues brought before the Board of Supervisors each month are often complex and difficult. Board members represent a diverse cross-section of Central Florida, and that diversity continues to serve the district well as the decisions are made relating to infrastructure, financing, growth management, and numerous other aspects of the administration of the broad scope of the district's responsibilities. Call to order, open of invocation, pledge of allegiance, safety minutes, or safety minute, public comment period on public hearing items. Consent agenda. Ratifying actions taken at May 1st, 2023, special board meeting, special meeting of the board. Informal items, no items. Management report, acting general counsel, financial advisor report. New business. Discussion and potential action regarding the selection of financial firm to assist in setting the utility rates for fiscal year 2024. Consideration of employment agreement with John H. Class. Consideration of employment agent agreement with Glenton Gilzine Jr. for district administrator. Oh, this is a 213-page fucking agenda. God, how do people operate like that? I'm probably gonna wrap up the show. I... Oh. Well, yeah, I've kind of lost steam. I'll Before I wrap up, I'll probably hit up oh yeah, I need to actually go here. The Dragon's Treasure, a haven for anime and tea lovers. if you were watching earlier in the stream, I was drinking a bunch of tea. And I was actually drinking a tea of fire and ice, which is a spearmint tea, or tea with spearmint flavors. And while it tastes good, I'm actually not too partial towards the spearmint flavor. I actually like more cinnamon flavors in my tea now. It might have something to do with the fact that I eat cinnamon in my burgers. But yeah, use code Layman at Dragon's Treasure, or at checkout at Dragon's Treasure, and get 10% off of your purchases. And you can get 10% off of everything. Your teaware, the tea itself, the Dragon's Treasure membership can be discounted, as well as the merchandise. And the membership is important because it's the only way you get access to membership types of tea and herbs and spices. You get these peppermint tea leaves, spearmint tea leaves. Oh, so there is a difference between peppermint and spearmint. Huh. He sold out on eucalyptus, so good luck getting that. So yeah, use code Layman at checkout for 10% off for your purchase, and enjoy fantastic saving with fantastic tasting tea. And with that, I think I'm wrapping up the show. I will admit I'm a little deflated. I started off pretty strong reading about the qualified immunity law article. That was very interesting, and I liked what I was reading throughout it. And I'll try not to bore my roommate brother with the details on that whenever I'm done, even though I find it particularly interesting. With that, thank you to everybody who came to watch. I'll probably restart the stream if Mindset it's like, hey, what's up? How you doing? And we can cover the Reedy Creek in a shorter form live stream. I don't think he anticipated the pressure or the idea that I was going to live stream it. So I did say it. Hopefully I made that point very clear. But with that said, thank you for anybody who came to watch. Thank you, Native Relish. It was nice seeing everyone who came to watch. Thank you for the views. I appreciate it. I am still especially astounded by the fact that basically the founding documents stream got 1,700 views, almost 2,000. I should have gotten like 30 cents out of that video. Hopefully that's how that translates. But with that said, I appreciate you guys coming. Remember to like and subscribe on YouTube and on Rumble. If you watched on YouTube, please go and watch on the Rumble side. If you watched on Rumble, please watch on the YouTube side. It's a little bit extra effort, but it helps my growth. It helps the algorithm for me, and I appreciate it indefinitely. You can find me on on Twitter at Legal Layman with 2 N's on the Layman, and at legallayman.locals.com, where you can find me, where I will update every time I do a stream from here on out. And I will also try to do exclusive content, but I'm hoping to get some kind of thing out of it before I can start making exclusive content. And I know that's a bit of a burden shift, and I apologize, but hopefully you guys will indulge me. And if you liked what you saw today, please go watch my previous videos. There's a quality difference between my first and my current video. Mostly in that my speaking is either a lot clearer now, I can read a little bit better, my understanding has improved a lot, but also like I used to get a little more tired out pretty quickly because I'd have to turn off the fans. I learned about noise gate and noise suppression pretty recently because I have a fan and a thing running over there, and that was pure silence. And hopefully the sound gate doesn't totally affect my voice in a way that I hope it doesn't. But of course, The quality's improved a little bit. I've made some changes to the format. Please go watch my previous videos if you haven't already. I appreciate the viewership. And once again, thank you for coming to watch the show. It means the most to me. And I will see you guys next time. I will stream Saturday, and I will stream the continuation of the Federalist Papers like I was supposed to today. But, you know, circumstances provided. I didn't quite do that. It's unfortunate. I'm a little deflated, not gonna lie. With that, hang loose, and I'll see you guys next time.